Hello, my name is Kim Block, and I am doing a workshop on navigating the BC Human Rights Tribunal system. I would like to acknowledge the Coast Salish nations of Musqueam, Tsleil-Waututh, and Squamish, on whose traditional and stolen territories I work, learn, and live. And I do want to acknowledge that this presentation is on colonial systems where the administrative and complaint systems are rooted in a colonial justice system. So to introduce, I'm not a lawyer. This is not legal advice. This is information based on my own personal experience navigating the system. And please view it as a Sunday brunch buffet of information. So whatever you want to pick and choose and put on your plate is totally to you. Um, you know yourself best and your family best, and this is just to provide you with as much information as possible. I will, however, though, not be able to tell you everything um, in the time of an hour, and I'm hoping that this is not going to take an hour. Um, so, this is just some of the highlights of what I think you should know. So, we have some external complaint systems in education, and they are work in silos, so they're very different. And today we're just focusing on the BC Human Rights Tribunal system. If you want an overview of all of these, then I have another video that you can watch. So people always ask me, what is it like? And I will say it depends, because what's true for one person isn't going to be true for everybody. It is all based on context. It depends on the age of your child, if they're going to be a witness, how far you want to go in the system. Depends on a lot of things. So the BC Human Rights Tribunal system is an independent quasi-judicial body, and it's similar in court, but it's more flexible, and the evidence rules are more flexible. It's not like criminal court where there's a very high bar beyond a reasonable doubt. It's more of a balance of probabilities, and it has the Human Rights Code and an administrative act that oversees everything. So, school district lawyers are defense attorneys. They're not judges. We need to frame this as it is. So, they will always do whatever is in the best interest of their clients. So, it's not personal. It doesn't matter who you are, they're still going to operate in this way. This is a legal process, it's a legal test that both sides need to prove. It doesn't mean your experience didn't happen, and it doesn't mean that your experience wasn't negative or harmful, but it does have to meet that legal test. And this is our most powerful advocacy route in my mind. And the Human Rights Code supersedes other laws and policies when in conflict. So this has the most teeth. So navigating this process is a skill, and it can be learned. So there's a code of conduct that is set out by the Canadian Bar Association, and you can file an improper conduct complaint with the Human Rights Tribunal, and you can read about that on their website. And or you could file a complaint with the Law Society, and it's important to know what you can file over. So just something to keep in the back of your mind, that if you feel like you're dealing with lawyers that you don't feel are dealing in ethical ways, this is something to think about. So many parents threaten a lot of things when they're heated and in high conflict situations with schools, but not many of them follow through with it. So they're not actually expecting a lot of parents to file human rights complaints. Human rights complaints are a big deal for school districts. And as a parent, if you're actually the one that takes that step, you will stick out in their eyes. So you will need to prove during this process that, they will. They will need to prove that your child in this process has had reasonable accommodations. They don't want to extend the amount of time for damages. They want to decrease that. So you will have district eyes on your child long after the human right complaint is complete. And I have to say, filing human rights complaints did bring full support to my kids. So many people wait to pull their kids first and then file, but you may want to consider filing before that point. Your conduct will be analyzed. So they will say, did you consult in good faith? Did you cooperate in good faith? And did you fulfill the duty to facilitate? And again, you will also be held to the bar that they could file an improper conduct for you for not following disclosure orders or being rude or using abusive language. Your complaint can get dismissed or they can apply for costs. So I like this picture. Dance like nobody's watching. Email like it might be read out at a tribunal. That is very true. So before you submit your complaint, I suggest you read the website and reread it because there is a lot of information on there. It takes time to process some of the information and you are expected to be aware of what's on the website. There is a 1-year time limit and I suggest you file if you want some help from the BC Human Rights Clinic to start early. So fill out a complaint form and submit it. You can submit one for your child. Then you have to submit another form saying that you are representing your child. So please read the whole complaint form because it will explain all of that. And then you also may want to write out your complaint as an attachment because you have up to 5 pages. On the form itself, they give very little spaces to write anything, but you can write 5 pages yourself and then you wait for a long time. It could be 10 months, it could be a year. When you send it in, the school will not know. So if you just want to send it in and not tell them, that's fine. The only time they will find out is when you get a response saying it's been accepted. Even if you get a response saying that it hasn't been accepted, they will not be informed. It's only when you get an accepted complaint. I've already explained all this. Yes, so the respondent will be the school district. That's who you write down as the form. It could be a decision of yours and a strategic plan to tell them that you have already filed a complaint. If you want to get their attention and get a reasonable accommodation sooner, that may work. You may want to file individual names. But just so you are aware, all the ones that I've seen, those have been dropped and the school district will accept responsibility for all of their staff. So they all go under the name of the school district. The contact person is the secretary treasurer. So when you write your complaint form, you're going to be telling your story in chronological order. Be clear. Don't be vague. Explain what happened. You can give details, describe events. This is creating the scope. And if you need help, please contact the BC Human Rights Clinic and they can help you. Here's the timeline. This gives you an idea of all the steps. And this is, I think, this is 2 years old. How long they think it'll take. It's roughly around the same from what I'm hearing. I don't think the times have changed. So the respondents have an opportunity to respond to your complaint. And I can tell you right now, it's going to be emotionally hard to read. I've never had a parent who hasn't felt that it's emotionally hard. They may refuse to mediate. They may not. They could submit a dismissal application, but in the process that's happening right now, a settlement meeting comes first, and then a case conference to discuss a dismissal comes after. So just by filing, it is a form of advocacy. Someone will read your story, and you will become part of the data of the yearly statistics. Sometimes acceptance can be very validating for parents. Some people have had success with sending a demand letter before or after they file a human rights complaint. Um, Sometimes that can have more meaning before you start to file complaints, like a TRB or an HRT. But really, this is up to you, and this is like the strategy. I can't say to you what's going to work and what's not. But if you search up small claims in BC and demand letter, you'll get a whole bunch of examples on the internet. So, common responses from lawyers, just in general, they will blame the parents. Blaming the victim is a part of many legal processes. So, this is very normal. Even though it's horrible, it's normal. This does not mean that their response is valid or that it will even be accepted by the HRT, but it is just a very common response, so be ready for it. It's not personal, remember, it's in their client's best interests. So lovely. They will always have an argument, always. They will always have a response, so just know that. Just because they have one doesn't mean that they're going to win. Doesn't mean that it's valid, doesn't mean they have evidence to support that argument, nothing. So I suggest you may want to think about having an approach with the BC HRT as try to come from a place of understanding, because probably most likely you're going to be confused. So you're always going to be asking things. So the BC HRT is responsible for ensuring administrative fairness and that you perceive your process to be administratively fair. So always ask questions during the process. And emails with your case manager are not private, phone calls are. So when you email them, you have to include the respondents. This process is slow, not necessarily a bad thing. You have time. I always found that actually helpful because I felt like I needed time. Details matter. So one sentence in a redacted email can change everything. And lawyers are taught to try and get every little advantage they can because those advantages build up over time. They can make a difference. So knowing that, don't let anything squeak by. Every detail is important. Read everything. So hearings, statistically speaking, a hearing is a rare event, but you still need to be prepared for it. So most likely you'll be dealing with settlement meetings or dismissal applications. So there's different types of mediation. There's a shuttle mediation, and no, you won't be blasting off into space. That's when the mediator goes in between the two parties, and the two parties are not in the same room. They have a mediation manual, and actually in the shuttle meetings, you aren't in contact with the lawyers. You will start 10 minutes early, and you'll be in different Zoom rooms. And there's links on the BC HRT website that I suggest you read for information. So the mediator will contact you a week before the mediation starts to arrange a 20-minute conversation. You can tell them anything that you want. So I sent an email to them once, and they emailed me, and I gave them some background info that I thought would be helpful. Technically, you can ask for anything in a mediation meeting, but not everything is enforceable by the courts. So you can ask for a written apology as part of the settlement item. Doesn't mean you're going to get it, but it's something that some people have gotten. Settlement offers and demand letters. You can send them a written statement offer at any time that you want. You just put without prejudice at the start of the email before you write anything. Dismissal applications can cost them around $20,000. That depends on the complexity of your case. Mediation meetings can cost them about $5,000 per lawyer for the day. So it's to them, it's a cost risk assessment. It's all about money. It's all about money. So the average, if you do the math, is about $15,000. The money will go for your child till they're 19. So how I got this average, and I'm not really a great math person. I took all the settlements and I divided it by the number of claims, and it came out to 15,000. Some are going to be higher, some are going to be lower, but they average around 15. You can send a demand letter before your case is even accepted or before you even file. Two parents I know have been successful going this route. So you can use a lawyer or you can write them yourself. And again, without prejudice, you can just Google that and get examples of demand letters. So a judicial review costs about $10,000, and losers tend to pay the winner's costs potentially. So they're about $20,000. Judicial reviews wins are most often not successful. That's what I've been told by lawyers. Now, these are just the cost of things that are going to come up that they could either choose or that you could even choose. But roughly around $5,000 to $10,000 per day for a hearing, and that's dependent on the number of lawyers you have, plus prep time, which I've been told is about $30,000 for a hearing. Hearings for education tend to be 5 to 10 days at least. More for more complex cases. We're talking about hundreds and thousands of dollars for a hearing. So you may want to think about that. The more you look like you are prepared for a hearing, the less likely they will drag you all the way to a hearing and offer you a settlement a couple weeks before a hearing. They sometimes do this. It's not fun. But what does a hearing look like? Because self-representing is very possible. Two parents have done that. And I've heard from other parents that they have a pro bono lawyers, that they will sometimes drop them right before a hearing, that pro bono lawyers really don't want to take cases to a hearing. So if you really wanted a hearing, you might want to think about self-representing. So they start at 9:30 and they go to 4:30. There's a 1-hour lunch. There's a break in the AM and in the PM. You start off by reading your opening statement, which you can read, and then the respondents will do theirs. Then you present your case first. So you testimony. You will do a testimony and testify. Mine lasted all day, and you have the burden to prove your case. So typically, when you think of how long the hearing is going to last, for 2 witnesses, you pick 1 day. And then you'll, depending on the number of witnesses you have and that they have, that's how they kind of guess how long the hearing is going to take. So the HRT website explains what is evidence and what kind of evidence you can submit. So remember, it's more flexible than court. Sometimes the respondents will allow you to submit things that you wouldn't normally be submitting if it's in the best interest of their client to just accept it, because they always want to minimize. So this is very common. They use delay as a strategy in many interactions, including district interactions, as I'm sure if you're watching this video, you probably are already aware. So one of the things you need to accept is emotional regulation, just to keep yourself going. It's good practice. You'll get very good at it. You'll develop all sorts of skills. Excuse me. So if you want to amend your complaint, you can add particulars, and that's where the scope of your complaint isn't changing. It's just the details. Or you can try and amend the scope of your complaint. You need to fill out an application, and it won't automatically be accepted, and the lawyers may argue it. They can give you moving target arguments, but the tribunal will need to approve it, but you can always try. So if you look up moving target, then you'll understand, it's like the moving target. But a lot of research will be very helpful. So my motto is to always try and always ask. You never know, magic does happen. And I do have to say that things have surprised me going through the system, where I was like, wow, I do have a chance. Magic does happen. They do try to make things as fair as possible. Um, so I would evaluate whether you think you're experiencing administrative fairness as you go through. They have the responsibility to try and make this as fair as possible. And one of the things I suggest is if you have a case conference is to ask for an agenda before the case conference so you know exactly what's going to be on it and the topics, and then you can do research on it, and then the lawyers can't surprise you on things that you aren't prepared for. So family status, you can fill out a separate complaint just for you. This is very exciting. Um, so you can file a complaint for your child and you, or you can not even file for your child, just file for you. Once it's accepted, you need to file an application to join them. That's if you're doing both at the same time. Pro bono lawyers, if you want a hearing, oh yes, I've mentioned this. I have heard them dropping parents before a hearing. So be clear about your goals if you're wanting to contact a pro bono lawyer and if you want them to take it to a hearing. The BC Human Rights Clinic, I have to say, was more giving than what I expected. I had about 4 hours and 45 minutes of one-to-one consultation time with a lawyer, and I spaced it out for when I really needed it, so that was very helpful. Lawyers and district staff will sometimes put in wrong information in emails on purpose to engage you, or they'll have technical difficulties. They'll enter things like the wrong date or the wrong year or confirming the number of emails they received, etc. This is intentional. They like to play these games to hook us, to test us, and hope you lose your temper. Because if you lose your temper, they can have your case dismissed. That's the easy way for them to make that happen. They can apply for costs for improper conduct. They will use the word inappropriate as a way to shame you or make you feel bad for advocating in certain ways. I feel like if you're getting the word inappropriate, then that means you're probably onto something. These are successful strategies for them and they have worked in the past. So I have seen cases being dismissed because people snap. So improper conduct, you can file on them. So keep a log of anything that you think is unethical. Keep the evidence, file a complaint with the Law Society or improper conduct. Those are your options. So something to think about. Always know you can withdraw at any time. It's what they want you to do, but just so you know, your mental health is key. And you have this as an option. At any time you just want this to be done, you can just file it and it'll be done. So sometimes it's really nice to just know that. Lawyers' response times, they will submit the day of the due date, not any day earlier. It's like within like 5 minutes of the deadline date. I don't know why I find that so funny, but I do. Sometimes 1 minute before it's due. It cracks me up. But that's what they're like. So if you think, oh, well, there's a due date in 4 weeks, I guess they're going to send me something anytime now. Nope. They will send it to you on the very last day. Same. So the lawyers may ask for a page increase and sometimes in response to an application that you submit, and you're going to want to say same. If they do that, then you also need to ask for the same page increase. You can say, since you will have more information to respond to from the respondents, you will also need the same number of pages as well. So just know that. That's good. Accommodations could be requested for the hearing process, including your child. So ask for what you need. Your child can answer questions via written at home alone if that is easier, for example, for kids with anxiety. Application process and gathering evidence. Consider the application process for documents. So you will need to argue why you want to ask them for certain things. And relevance and credibility are a couple reasons as to why you would need those things. So never assume that they have given you everything through document disclosure. Never assume that, because I guarantee you, I don't think they have. You will probably want to ask for things. And this is where you need to put on your detective hat and figure out what is missing and what you need. So if you make it to the document disclosure phase, which is right now, it would come after a settlement meeting, things that you don't get from the OIPC if you filed, you can get through the HRT application process. Things that they swore no longer existed. Made an application and poof, it was like magic. Suddenly it appeared. So the Human Rights Tribunal has stronger teeth than the OIPC. So make applications for everything. Even things that you didn't get in the past, ask again. If they give you anything redacted, always ask them to remove the redactions. If they remove some but not all, keep asking them to remove them. If they refuse, contact your case manager. Orders to attend. I strongly encourage you to consider filing these. Don't let them hand them out themselves. You have a right to do that. They don't like these. I think it decreases the likelihood of them dragging you and offering a settlement only weeks before a hearing. And I think it helps to make the hearing happen. But that's just my personal opinion. But orders to attend, you may want to think about that. I think they're helpful. Closed hearing. If your child is going to be testifying, you can make an application for a closed hearing. This isn't really advertised on their website. The tribunal does lean on protecting minors' privacy, but again, you'll have to argue it in an application. I highly suggest you attend public hearings. You can learn a lot from them. So you can attend a public hearing by phone and listen in. Excuse me. I have found this to be very helpful. You don't need to have an accepted complaint to do this. Anyone can. You just follow the instructions on their hearing page. I would also suggest you read case law because that's what you're going to need for some of your arguments. This is an example of actually what you don't want. So this mother was not believed, had credibility issues, and it was all hearsay and double hearsay. Her knowledge was mostly through her child. So it's good to read these cases. In summary, emotional regulation is key. Administrative fairness, always ask, always try. Keep your eyes open for improper conduct from the lawyers. Be hearing ready. Applications will be your friend. Gathering evidence. Drive up the lawyer's fees. Be expensive. Remember, to them, it's all about money. This is possible. This is your most powerful advocacy route. And if you get any decisions throughout your process, fabulous. Because if they post them, then they feel like they've advanced the human rights code in some way. So that's very important. If you have any questions, this is no longer my email. You can find me on my website, and my correct email address is there. It's kimbpath@gmail.com. So thank you so much for listening. I hope you have found some of this information helpful. Please contact me with any kind of feedback. And that's it. All right.